This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys and the prosecutors are present. We are outside the presence of the jury. Ms. Brady, did you want to, actually before I turn it over to you to discuss the issue that came up in terms of the media before the lunch break. In ruling on the objections to the people's PowerPoint presentation, I think I forgot to rule on one of the objections, which was slide number 49, that I think indicated at least 76 shots and at least 670 individual projectiles. And I think the objection was related to these statements being a misstatement of the evidence. Mr. Orman provided an explanation that satisfies me that it was an appropriate slide. I gave the jury an instruction that says ultimately they decide what the evidence is. The parties can disagree, but ultimately they determine what evidence was admitted. But I think given the explanation by Mr. Orman, I felt comfortable that this was not an inaccurate slide. So I wanted to supplement the record with that. All right, now let me turn it over to Ms. Brady.
We're going to have Ms. Nelson make this argument to the court.
Okay, Ms. Nelson.
Yes, Your Honor. We were able to obtain capture a copy of the tweet itself, as well as a copy of the tweet along with some other tweets from other news organizations tweeting about the tweet. If I may approach your staff with the two exhibits that I've marked as CTR 98 and CTR 99.
Yes, actually, why don't you give them to me first so that I can see
May
them.
I approach?
Yes.
Oh, sure.
Yes.
No objection to the court receiving these, Your Honor.
Okay, thank you. Thank you. Sorry. Ms. Nelson?
Your Honor, this is obviously a violation of Order C-197 that was issued on April 20th of this year that prohibits members of the media from publicly identifying any juror or publicly providing any information that was not disclosed in court, and that could reasonably lead to the identification of a juror. That was an order that was issued by the court sua sponte. The juror's privacy in this case is obviously an important issue for the court, and it's also important to the parties. And the court has taken many steps to protect the jurors and the jurors' identities in this case. As I stated, it's a concern that is shared by the parties. Ultimately, however, it is the court's responsibility to determine the sanction for this conduct by the media and how to proceed. The defense has several options that it thinks that the court should consider taking. The first would be to ban Newsweek from being present in the courtroom, which is the sanction that the court indicated it would impose for a violation of C-197. A violation of this order will result in the violator and any organizations with which he or she is affiliated being immediately barred from the courthouse and courthouse premises during the remainder of this trial. The court should also consider whether any of the other media organizations that tweeted information about this tweet should be subject to the same sanction. In addition, we think it would be appropriate for the court to consider issuing an indirect contempt citation under Colorado Rule of Civil Procedure 107, and either as part of that contempt proceeding or in addition to that contempt proceeding, consider appointing a special investigator, a special counsel to investigate this issue and how it came to pass that the media got a hold of this juror's information and published it on Twitter. It's ultimately up to the court. It's our position that the court should act swiftly and send a strong and important message to the media that this is a very serious violation It will not be tolerated, and if the media violates a court order, that there will be severe and serious consequences.
All right, thank you. Anything from the people, Mr. Orman?
I'm just trying to think this through, and I don't disagree with what Ms. Nelson said in any particular way. I'm just, and you know, I guess I took con law a long time ago when I was in law school, and I guess I know a little bit about freedom of the press and whatnot, but certainly I'm no expert on that. But so I'm just trying to sort of think through this just legally, step by step. The court, I think, has the power to regulate the people that are in the courtroom, and I would assume that Newsweek was in the courtroom. I believe that is the case. I don't know how they got the name of this juror. It could be that they recognized him. You know, stranger things that happen. It could be that they took information from voir dire and put two and two together and figured it out that way. It could be that somebody told them. There could be a bunch of different ways that they got that information. The court obviously is limited in its power. I see a note being brought in. Do you want me to wait to continue, Your Honor?
No, you can continue.
So, and I don't know what those limitations are. I don't know what those limitations are. So, and I don't know what the court should do. I think counsel, I'm kind of surprised, frankly, that tweet was still there. I would have thought that an organization like Newsweek would have deleted that tweet as soon as they heard about this, and I would have been surprised if they weren't watching on that camera right there. So that's surprising to me. It's somewhat shocking to me that was not deleted. And I guess I don't have anything else to say, Your Honor. I mean, you can certainly ban people from the courtroom. You can't ban everybody, nor would you want to. But unless you have a question for me, Your Honor, that's all I got.
No, thank you. It's my understanding from the judicial branch's public information officer that there was actually a story about this from Newsweek. And as soon as he became aware of it, he contacted the reporter and had the reporter take it down after he showed the reporter my order, or forwarded to the reporter my order. He was not aware of the tweet, but the information was taken down. The tweet wasn't, and maybe it hasn't been taken down yet, because Ms. Nelson was able to print C-TR, C-TR-98 and C-TR-99. But Mr. McCollum, who's a public information officer for the judicial branch, once he became aware that there was this information out there with the juror 737's name publicly displayed, made contact with that reporter, forwarded a copy of my order C-197. It's my understanding that the reporter and Newsweek have agreed or have indicated to Mr. McCollum that they're not intending to cover any part of the proceedings from here on out. I still think it's appropriate, even notwithstanding that apparent agreement, for me to issue an order banning not only the reporter but Newsweek from being in the courthouse, not just the courtroom, but the courthouse premises, as long as these proceedings are ongoing. In terms of whether any other media organization should be sanctioned, I'm not aware of any other media organization that published the same information or that republished the same information. If the parties are aware of that, I would like to know about it, because that too would be improper. I don't know how Newsweek or this reporter from Newsweek found out about Juror 737's name, but frankly, Newsweek should know better. And it is really disappointing that something like this happened, especially given my order. And, you know, the record should be clear. that this case has received a lot of media coverage, a lot of media attention. There have been members of the media sitting here for months, and a lot of them, and they all have been professional. They all have complied with my rules. I think the only incident that I'm aware of that has taken place happened with respect to the contact between someone from Yahoo News and Marcus Weaver, and that was pretty mild too. And so everyone has complied with my orders. Everyone has done what they're supposed to do. And then here's someone who apparently thinks she's special, and she's not subject to my rules, and she's not subject to orders, and she can do apparently whatever she wants. So I'm going to issue an order not only prohibiting her from being on the courthouse premises while the proceedings are ongoing, but prohibiting Newsweek from being on the courthouse premises while the proceedings are ongoing. In terms of any other media organizations, if counsel become aware or are aware of any of them, I would like to know about that. In terms of the request for direct contempt, I actually think it would be indirect contempt, because direct contempt would be if it happened in the courtroom.
No, Your Honor, and if I misspoke, I meant to say indirect.
Okay.
I thought I did, but that's what I meant.
I may have misheard you. I thought you said direct, and I don't think this would be a direct contempt situation, and Ms. Nelson agrees. So to the extent that you said direct, then to the extent that you said direct, it sounds like that was inadvertent. But I don't think any further action is necessary. I think that issuing an order preventing Newsweek from being in the courthouse or being on courthouse premises while the proceedings are continuing is sufficient. Mr. Orman.
Your Honor. And I am not asking the court to take any additional action, but since I know this, I just thought I would mention to the court. My understanding is that Newsweek actually, Newsweek publishes websites and stuff under different names, and I don't know if Your Honor is referring to a corporation or just that title, Newsweek. I'm pretty sure there's a website called The Daily Beast, which I think is owned and run by Newsweek. I mean, that could have changed. They may have sold them. So I just thought I would mention that to the court. It's a strange name, but that is my understanding. So, and I'm not asking the court to do anything. I just thought I would mention that.
Okay, I'm going based on the information that I've been presented, and what I've been told is that it was somebody from Newsweek, and the two exhibits that were submitted by Ms. Nelson, which are C-TR-98 and C-TR-99, have the Newsweek logo on them. So, all right. By the way, the jury has a question. Since I have you here, we'll mark this as question number 1 during deliberations, during phase 1 deliberations. And the question is, the jury requests a TV/DVD player to view evidence, and then it appears to be signed by the foreperson. Do the people have a position with respect to that request?
Well, I think that they should be able to view whatever evidence they want that's been admitted, and I don't remember exactly what procedure the court wanted to follow, and I don't know what the court had in mind about just giving them a DVD player or having them watch it in the courtroom. Different judges I've seen do it different ways. This is the first time this has come up. I have a feeling I know what they want to watch.
All right. Does the defense need a little time before we proceed on this?
We would like a little time, Your Honor, if you don't mind.
I don't mind at all. I think that's appropriate. Is it okay if I give you about 15 minutes? Does that give you enough time, you think?
Yes, it does.
Okay.
And I just have just a brief further record to make on the issue of Newsweek.
Yes.
Based on what we could tell, just so the record is clear, Newsweek itself has taken down the tweet. However, because of the nature of how this stuff works, there are still secondary websites, including a website called inagist.com that apparently is a website that algorithmically curates tweets based on popularity in real time. And if you Google some terms that are pretty easy to figure out, you can still pull that tweet up on that website. In addition, Mr. King pointed out to me that there's now an article in USA Today already discussing the issue of Newsweek being banned from the courtroom from publishing a juror's name on Twitter. And in addition, as the court exhibit that I provided to the court just a few moments ago indicates, there have been some other news media organizations, including 7 News and Colorado Public Radio, that have also tweeted about this incident. And then if people Google terms that are related to this incident, it would be very easy to still pull up this tweet. So it's a very serious problem, and we think the court should take some further action.
With respect to Newsweek, is what you're saying?
Or anyone who has retweeted this information.
Well, in terms of Newsweek, I continue to be satisfied that the punishment that I have imposed is sufficient. In terms of anyone else who has retweeted it or has republished it, it has to be the juror's name. I mean, if agencies are reporting on the discussion that we're having and what has been brought to light today, I don't think they're in violation of my order. If agencies are publishing any jurors' names, whether they're just retweeting or republishing it, then I think that's a concern. So again, if I hear that there are other organizations that have done that, then that may be a different story in terms of whether I take action as to those other news agencies. But if a news agency is just reporting on what's happening here today in terms of the discussion without mentioning the juror's name, then that's not in violation of my order. So we'll take a break. We'll take 15 minutes, and then I'll give you folks a chance to think about the request from the jury. Mr. Brockler?
Your Honor, may I, just to give the court something to consider in light of where we're at, and if this isn't timed well, please let me know. Just after we broke for lunch, Ms. Higgs was nice enough to bring over a PowerPoint presentation that they'd like to use presumptively for the second phase. And I would make a record about that when the court's prepared, but I have a copy for the court if it would like it in advance of this break.
Okay. Yes, please. Any objection to me having that? No? Okay. Thank you. Yes. All right. Thank you. By the way, the other question, going back to the issue of the juror's name, juror 737's name being published, is whether I should tell him anything in terms of I've addressed the issue or something along those lines. I know that he was concerned and he seemed unhappy with the fact that he was aware that there was an order in place preventing the publication of any jurors' names, and he was also aware that apparently his name was published by Newsweek. So I think it would be appropriate, not while deliberations are going on, but if the proceeding continues, to bring him in at some point and just say, I've taken care of it, and leave it at that. Is that okay with the people?
That's fine with us.
Is that okay with the defense?
Your Honor, we think he should be informed of something. I'm not sure if I'm taking care of it is sufficient, but, or maybe the court has taken appropriate action. But yes, I think he should be informed.
Okay, the court's taking appropriate action is fine too. It sounds like the same thing, but I'll say the court's taking appropriate action. That's fine. Okay, we'll be on break for about 15 minutes. The court's in recess. Thank you.
All rise.
The people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. My staff has distributed to the attorneys a copy of the request from the jury. I have marked it as jury question number 1 during deliberations in phase 1 of the sentencing hearing. What's the people's position on the jury's request? I think you said already that you don't have any objection to me sending a TV and DVD player to them.
Your Honor, we've looked at some cases on this, and it appears that the court has discretion. But the case I think is, well, it's a Colorado Supreme Court case. It sort of describes the process the court should go to. DeBella, D-E-B-E-L-L-A, versus the people, 233 Pacific 3rd, 664, with the pinpoint site of 666, Colorado Supreme Court 2010. There's a case this year from the Court of Appeals, People versus Riley, R-I-L-E-Y, 2015 Court of Appeals, COA 79. That's that new citation format they have. And it's numbered paragraph 38. And I think what DeBella would say is the court should exercise its discretion, consider whether it would aid the jury and whether it would be unfairly prejudicial for the jury to use it. So I think actually we need to know what they want to look at.
That's what I was looking at in terms of the standard that I'm supposed to apply. I looked at Jefferson, but I'm familiar with DiBella from the Supreme Court, People versus DiBella, which is I think 212 Pacific 3rd, I believe, 666. And I'm also familiar with Frasco, 165 Pacific 3rd at pages 704 and 705. But Jefferson is People versus Jefferson. This is a Colorado Court of Appeals case from 2014. It's 2014 Westlaw 2769104. And it says, generally, a jury is permitted to take into the jury room all exhibits received into evidence, subject to the trial court's discretion to order otherwise. The trial court, however, has an obligation to ensure that evidence is not so selected nor used in such a manner that there is a likelihood of it being given undue weight or emphasis by the jury. This obligation is particularly pronounced with respect to jury access during deliberations to portions of trial testimony and to exhibits substituting for trial testimony. Now, I don't think we have any exhibits right now in the deliberations room that contain trial testimony or substitutes for trial testimony, but the rule doesn't apply only to trial testimony or exhibits that would substitute for trial testimony. It is more pronounced in those situations, but it applies to all exhibits. And in Jefferson, the court said that a trial court must oversee with caution the jury's use of exhibits of a testimonial character, including video recorded interviews of witnesses. Again, I don't think we have any such exhibits back in the jury room right now. Then the court said that the trial court must exercise its discretion to permit, deny, or limit the jury's use of a testimonial exhibit by assessing, one, whether the exhibit will aid the jury in its proper consideration of the case, and even if it would, two, whether a party will nevertheless be unfairly prejudiced, by the jury's use of the exhibit. Ultimately, the court has an obligation to assure that juries are not permitted to use exhibits in a manner that is unfairly prejudicial to a party. So even though that part of the opinion that discusses the two-prong analysis is specifically referring to a testimonial exhibit, and we don't have testimonial exhibits, I don't believe, in the jury room right now, I still think that the most prudent course of action is to apply the analysis now to the jury's request. But my question is, similar to the issue that was raised by Mr. Orman, how can I do the analysis if we don't know which exhibit the jury wants to see? And as much as I am disinclined to want to ask the jury for specific information during its deliberations, it seems like that may be the way that we have to go. But I'll hear from Ms. Nelson. Ms. Nelson, what do you think? What are your thoughts?
We agree.
And so is it okay with both of you then if I send back a question asking which exhibit or exhibits the jury is interested in viewing?
Yes.
Okay, I will do that. I will state it just like that. And then we will send it back to the jury room, and then I'll give you a copy of that question. And then as soon as we get an answer, I'll let you know, and then we'll have a discussion. Okay? All right, the court will be in recess again. Thank you. And his attorneys are present, and the prosecutors are present as well. I sent back a note in letter format indicating as follows: Dear members of the jury, this is in response to your request for a TV/DVD player to view evidence. Which exhibit or exhibits are you interested in viewing? And then I said sincerely, and then I signed it. the jury responded as follows. In response to which exhibits we wish to watch on DVD, People's 789, which is, well, let me read it and I'll tell you what each one is. People's 789, People's 1023A, People's 400, People's 401, People's 1103. And then it is signed by the foreperson. I have marked that response as jury question number 2 during deliberations in phase 1 of the sentencing hearing, 12 CR 1522. Could you folks please give the attorneys a copy of that? 789 is the video interview of the defendant from July 20, 2012. 1023A is the audio interview of the defendant by Agent Gombiner and Detective Apple. 400 is a theater surveillance lobby video, as is 401 and 1103. All three of those, I believe, are surveillance lobby videos. And just so the record is clear, these are all people's exhibits, so P-TR-789, 1023A, 400, 401, and 1103. To the best of my recollection, 789 is about 10 minutes long. It's short. That's the interview by Detective Mel and Detective Apple that happened shortly after the defendant's arrest. 1023A is about 40 minutes long, I believe. That's an audio taped interview. 400 is a surveillance lobby video, and I don't know how long exactly 400 is. Some of the surveillance videos are longer than others, but I would estimate that the 3 surveillance videos that the jury has asked for amount to approximately 15 minutes at the most. Those are my best estimates. So based on that, how do the people want to proceed? Mr. Orman, do you want to make a record in terms of the analysis and the standard that I spoke about earlier?
These are admitted items of evidence. I think the jury should be able to listen and watch them, listen to 1023A, watch the rest of them. I think the question becomes how the court wants to do that. I don't think there's any analysis that the court can go through that the jury doesn't get to see this evidence. They want to see it. It's been admitted. It seems to me to be, certainly 789, I think is relevant because the defendant makes a statement about a child in that video. 1023, I don't think there's any questions about the theater at all in that. It's all about the apartment, but so I don't know exactly why the jury wants to listen to that, but maybe they're curious as to whether maybe there was something about the theater in it. I'm not sure. 400, 401, and 1103 are all going to show the people coming in and out of the theater. 400, I believe, would show the defendant walking in and the various people there. I think 401 is the defendant, is all the people fleeing from the theater. And 1103, I believe, is the very brief portion that shows Veronica Mosier Sullivan. So I think all of those are relevant, and the court in its discretion should allow the jury to watch them. The question becomes how, and I would just submit to the court's discretion on that.
All right, and before I get to Ms. Nelson, let me correct what I said earlier. I said that I couldn't remember that the jury had any testimonial exhibits. The jury has a couple of them, at least a couple of them. 789 is a testimonial exhibit. That's the videotaped interview of the defendant shortly after the arrest. And 1023A is also of a testimonial nature, and that is an audio-taped interview of the defendant by Agent Gombiner and Detective Apple. All right, Ms. Nelson?
Your Honor, our request under DiBella, which does grant the trial court discretion to craft the right procedure to assure that the jury does not use these exhibits in a manner that's unfairly prejudicial to a party, would be to have the exhibits at issue played either in the deliberations room or in open court in the presence of the bailiff, that the court instruct the bailiff on the record that the bailiff is to play the exhibits for the jury once, not to speak to the jurors or answer any other questions, and to report back to the court what happened and to put that on the record.
Okay, thank you. First of all, let me go through the analysis that the case law talks about. First, I have to assess whether the exhibits will aid the jury in its proper consideration of the case. And I find that these exhibits will aid the jury in its proper consideration of the case. There's been no argument to the contrary, and much less showing to the contrary. And I believe that all of them would be helpful. The one that's the closest call is the audio taped interview of the defendant, because that interview was limited to the apartment and did not have to do with the theater. But it's possible that the jury is being thorough and trying to review the exhibits, including that one, the one that I just mentioned, 1023A. In fact, that would be the most reasonable inference from the record, and the most logical inference from the record is that that's what the jury is doing. Clearly, the other ones are directly relevant to the determinations that the jury is attempting to make at this time in terms of the alleged aggravators. The videotaped interview makes mention of a sign that refers to children, and the defendant asking a question about that sign. And then the other three videos, 400, 401, and 1103, show they are surveillance videos, and they show the lobby, and they show the people who were in attendance at the theaters at the time, either immediately before the shooting, or immediately after the shooting, or actually during the shooting. And it would be relevant, I think, in terms of seeing whether there were children there, how many people were there, that kind of thing. But specifically, I think it would be to assess how many children appear in one or more of those surveillance videos. The second part of the question, or the analysis, is whether a party will nevertheless be unfairly prejudiced by the jury's use of the exhibit. I agree with Ms. Nelson that there should be limitations placed, and with those limitations, I am confident that neither party will be prejudiced unfairly, much less unfairly prejudiced. There has been no showing to the contrary, and or even an argument to the contrary by either side. What I propose doing is as follows, and there are different ways to go about this in terms of what limitations to place. Here is the type of response that I would propose, that I propose to the parties. Dear members of the jury, this is in response to your request for a TV/DVD player to view exhibits P-TR-789, P-TR-1023A, P-TR-400, P-TR-401, and P-TR-1103. The request is granted. However, the court instructs you that you are not to give any exhibit undue weight or emphasis. Consistent with this instruction, you may only play each exhibit one time. Further, you will only have the TV/DVD the TV/DVD player approximately 75 minutes, which is approximately the length of all the exhibits you are interested in viewing. Finally, you may not play any other exhibits without authorization from the court. If you need additional time, please let the court know. Sincerely, and then you would have my signature. Do the people have a position on that proposal?
Your Honor, I don't. Would you like me to get with my paralegal and sort of add up the times?
You
for that,
can.
so we can get the court a real total number?
Yes, please. My best estimate is that the total will not exceed 75 minutes, but that's just my estimate. And while he's doing that, let me just say that my preference is to not have the bailiff supervise the jury while the jury is watching exhibits for a couple of reasons. Number one, sometimes jurors want to have discussions as they're watching a video or listening to an audio tape, and they would not be able to do that if my bailiffs are present. Number two, I don't think bailiffs should be present while the jury is watching a particular video or listening to a particular audio, and should be part of any of the proceedings where the jury is figuring out what evidence to view and how much time to spend on a particular exhibit. I'm giving them instructions, and I trust them that they will follow my instructions. And my preference is to place limitations and to not have the bailiffs present while they're viewing the exhibits. I think that the better practice, in my view, is to have them do it on their own, but to have limitations placed on them. The truth is that we're relying on them to follow the court's admonishments in other regards, and it doesn't make sense to trust them in that way, but not trust them with respect to these exhibits. And if I limit the time that they have the equipment available to play the exhibits, then I think it forces them to view them only one time, to not be going, to not replay any particular video, and to comply with all the instructions that I'm giving them. Ms. Nelson, I'm sorry, were you going to say something? By the way, you did say indirect when you were talking about contempt, so it was my mistake, not yours. Go ahead.
Thank you, Your Honor. I apologize. We had there was a long list of exhibits that the court read out, and after I made my record, we were thinking some more about them, and it occurred to us that 1023A, which is the audio taped interview, was the subject of motion D-127, and it was our position, and continues to be our position, that that interview with Mr. Holmes violated his Fifth and Sixth Amendment rights, and that was the issue that the court ruled came in under the public safety exception to the Miranda doctrine. And so we would object to the jury viewing or listening to that audio tape because we continue to maintain that it was a Fifth and Sixth Amendment violation, and that that would be used in support of aggravation. And so we would also cite to Estelle versus Smith, Satterwhite versus Texas, and Powell versus Texas, as well as the Eighth Amendment in Colorado Constitution, Article 2, Section 20.
Okay.
We also continue to maintain our position that the bailiff should be present.
Yes. Mr. Orman?
Your Honor, thank you. Going through our records, I think the 1103 is the shortest. I think it's like 45 seconds.
Okay.
That one, that's just from memory, but I remember it being very brief. 401, I'm just going to go backwards sort of. 401 is a theater surveillance video. It is 2 minutes, 56 seconds long.
Okay.
400 is another theater surveillance movie, and that is 7:30. 1023A, which is the audio of the interview with Detective Apple and Special Agent Gumbener, is 32 minutes and 8 seconds. And 789, which is the video interview with Detective Apple and Detective Mel, is 4 minutes and 14 seconds long. I didn't add all them up because I just got the information straight from the paralegal, so if you want me to do that, I can endeavor to figure out how many minutes that is.
That's okay. It's about 50 minutes total, so it's a little less than what I thought. Let me ask you about 1023A. I don't know if you heard the objection from Ms. Nelson. Ms. Nelson is right. This was the exhibit that was subject to Order D-127, which was an issue that was litigated thoroughly, and that I issued a lengthy and thorough order on. My concern about 1023A is that it's, of all the exhibits, it's the one that has that is the least valuable, as far as I can tell, for the jury's consideration of the case, at least at this phase of the proceedings.
Your Honor, I can't disagree with that, because there is nothing on that audio that pertains to the theater. So, but, the question is, Your Honor, and the issue I see is, the jury is obviously wanting to be thorough and listen to everything. And I can see a juror saying, I just really need to listen to 1023A to be sure that what's on there, if there's any information that is relevant to any of the issues. I mean, we're assuming that it's for the aggravator number 2. Yeah, we don't know, though, right? They haven't said, we wouldn't ask them. We don't know exactly what aggravating factor it is. We're just making that assumption. And I think it's a reasonable conclusion based on the 5 items that they want to watch and listen to. But we don't know that for sure. So I don't believe the court limited the admissibility of that evidence of 1023A. So I hear what the court is saying on that, and I understand the objection counsel's making. I mean, the court has found it is admissible in general. So I would say that the jury should be able to listen to that if they want to, and watch the other things if they want to watch them. I have a response to the question about the bailiff, if you want me to talk about that now, Your Honor.
Sure.
My position is, I mean, I was thinking this through. I understand what the court is saying, and I agree with the court that the jury should watch this stuff alone, and if we time it right, they won't be able to do all of the different things that people are worried about of, repeating the same thing over and over again and pausing and then talking and then going on. The issue of having someone in there, though, is, I was thinking about it. Let's say I've had some judges say, if you want to watch a video, you're going to come into the courtroom with the lawyers, you're going to sit in the jury box, we're going to play it in court. And I was sort of thinking through how that would work. Well, we would all sort of be able to see their reactions. The gallery would be able to see their reactions if we were going to do it that way. And the court's not talking about doing it that way. But that's sort of the first part of the way I was thinking this through. So I was thinking through then, okay, what if it's just the bailiff? And the bailiffs then would be able to sort of see their reactions and what their facial expressions were or their body language or something like that. And I know your bailiffs aren't going to share that with anybody. I don't think they'd share it with you, Your Honor. But they would then have that information later on about sort of the way the jury was interacting with themselves almost, thinking about stuff. And I don't know that that's really appropriate for anybody except those 12 citizens to know. So I agree with the court that the bailiff shouldn't be there. I think that if we time this right and give them an adequate amount of time, they're just going to watch this stuff and they'll be done. So that's my thought on it, Your Honor.
Well, and there's also a risk that a juror might also, the jurors might inadvertently say something in front of the bailiffs. I've always taken the view that deliberations are sacred in a way, and nobody should be part of that. Nobody should see any of the deliberations at any point. I know that the case law allows for that to be a particular method that can be used if the jury wants to watch a video or view certain audio evidence, but I think the better course of action is the one that I have outlined, so I'm gonna stick with that. Let me think about the objection that was made to 1023A in terms of motion D127 and my order D127. Let me think about that for a couple of minutes, a few minutes, okay?
Your Honor, if I can just say one more thing.
Yes.
Regarding 1023A, I just want to put it out there that it's possible, and I'm not saying I believe this to be the case or I don't believe it to be the case, I just think it's possible that the jury wants to listen to that to know about the effort the defendant made to delay the police or other people from getting to that theater, because he talks about that in the conversation with Detective Apple and Detective Gumbener. One of the aggravating factors is that grave risk of death to others. And it could be the reason the jury wants to listen to that is because some of them may be considering or thinking about whether the effort to divert the police or others to the apartment, which he talks about in that audio, is relevant to the aggravating factor of a grave risk of death to others by potentially delaying law enforcement response and treatment by paramedics, firemen, and so forth. So I just thought I should say that, Your Honor.
All right, give me a few minutes, and then I'll make a decision. Okay, the court will be in recess.
All rise.
This is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Going back to the Jefferson case, and Jefferson relied on Frasco and DiBella, both which are Colorado Supreme Court cases. The two-prong analysis that I've gone through stands, and there's been no argument by either party that two-prong test has not been satisfied here. And when I look at the aggravating factors that have been alleged, one reasonable possibility as to why the jury wants to listen to the audio recording is to determine whether there was mention of a child in that recording or in a different recording. Another reasonable possibility is that the argument Mr. Orman made, which is that the jury may be focusing on a different alleged aggravating factor, and that is that whether it goes to the defendant knowingly creating a grave risk of death to another person in addition to the victims of the first-degree murders. And there is some conversation in the audio recording about diversion. Another reasonable possibility is that the jury could be assessing the alleged aggravating, the aggravating factor that alleges that the defendant committed the offense of murder in the first degree in an especially heinous, cruel, or depraved manner. Again, the discussion on what the purpose of the setup in the apartment may go to whether the shooting was, and the murders at the shooting, during the shooting, were done in an especially heinous, cruel, or depraved manner, and specifically, it may go to the issue of whether there was unnecessary torture. And so given that there's no disagreement, no dispute in terms of that two-pronged test, I continue to find that the two-pronged test has been satisfied. The objection is with respect to motion D-127, and Ms. Nelson is right that that motion was filed, and I ruled on that motion, and as I indicated in my order D-127, it was a close call for me. But the reality is, I ruled that the audio recording was admissible. The audio recording was admitted into evidence and was played for the jury here in the courtroom. So given all that, at this point, the record is made with respect to the defense's objection, but it's an item of evidence that has been admitted, and I will treat it the same way as any other item of evidence that was admitted, as long as the two-prong analysis or the two-prong test in Jefferson and Frasco and DiBella is satisfied. So for those reasons, I will overrule the objection in terms of Exhibit P-TR-1023A. Here is the response that I have drafted. Dear members of the jury, this is in response to your request for a TV /DVD player to view Exhibits P-TR-789, P-TR-1023A, P-TR-400, P-TR-401, and P-TR-1103. The request is granted. However, the court instructs you that you are not to give any exhibit undue weight or emphasis. Consistent with this instruction, you may only play each exhibit one time. Further, you will only have the TV/DVD player for approximately 60 minutes, which is consistent with the length of all the exhibits you are interested in viewing. Finally, You may not play any other exhibits without authorization from the court. If you need additional time, please let the court know. And one time is in bold. So the part where I say that you may only play each exhibit one time, that is in bold font to provide some emphasis to it. I'm going to make a copy of the letter for each party, and then each party will have a copy. Is there anything else at this time on behalf of the people, Mr. Orman? Anything else at this time on behalf of the defense? Okay, thank you. All right, the court will be in recess. Thank you.